Turner.
My Lords, my Lady, good morning. I appear for the appellant with Mr Robin Green and Mr Matthew Finn, and my learned friend Mr Lewis QC appears for the respondent. Can I start briefly with a piece of housekeeping? On Friday, you should have been provided with a copy of what we call the permissions bundle. You don't need to refer to it. It seemed to me that you might find it helpful to have a chronological bundle of the permissions. You can ignore the supplementary bundle for reasons referred to in correspondence you may have seen. There's one more document I'll give to you when I get to it, which is an extract from the explanatory note to the Levelling Up Bill. You may have seen reference to the bill itself in Mr Lewis's case. The relevant part of the bill is in the authorities, but not the notes. It seemed to us, again, that you may find it helpful to have those. Rather than give them to you now and risk you losing them, I'll give them to you when I refer to them. By way of introduction, my Lords, as you know, the Statement of Facts and Issues, paragraph 40, defines the overarching question for the court. That's at MS 36 and 37. And how I propose to structure my submissions in response to that issue is firstly take you to the central features of the background insofar as they're essential for understanding the context of legal submissions. And then I'll develop the 8 numbered submissions in the printed case that we've provided to the court and elaborate on, develop those submissions, including my response to Mr Lewis's case. So can I start, my Lords, with the 1967 permission? That's at page 231 of the electronic bundle, or permissions bundle number PB2. And that is the 1967 permission, granted, I should add, when the Snowdonia National Park was in existence. There seemed to be some misunderstanding below as to whether or not the National Park was there at the time. It was, since 1951. You'll see there's no condition tying the development to specified plans, but the common position of the parties has always been, and indeed Mr Justice Drake found, that the reference in the first bit of printed text to the development proposed by you in your application incorporates by reference the 1967 master plan. And Mr Justice Drake held that, we don't need to go there yet, but page 257 of the electronic bundle, page 8, B to C. Then next is the 1967 master plan, and that's at page 220 of the electronic bundle, 220. And as you'll see, that is the master plan which the judgments below referred to. It relates to a large development over a considerable area, and for reasons I'll show you shortly, that was a point which Mr Justice Drake thought was of some significance in construing the later permissions. Putting that to one side, prior to the 1987 judgment of Mr Justice Drake, as the court knows, various additional permissions were granted. Each of these was applied for and granted in full cognizance of the 1967 permission. And they were intended, as Mr Justice Drake found, to operate, and did operate, as amendments to what had previously been approved. And I'll explain what I mean by that shortly. Can I, rather than take you to those permissions, you have them in the bundle, can I take you to the findings of Mr Justice Drake, because that's going to be the quickest way of dealing with the pre-87 permissions. And the relevant part of his judgment starts at 263 of the electronic bundle. Internal in his judgment, page 14. And the first passage I wanted to draw your attention to is quite long, so it may assist if I just ask the court to read or reread it. It's 14A to 15B, which is...
Is that 263?
It's 263 in the very top of 264. So my lords will see a clear finding by the judge that the pre-87 permissions were variations in the terms I just described. That's reiterated.
That's a finding, but is that a question of fact that was evidence before Mr. Justice Drake, or is it a question of law?
It's a question of law, because it's a question of interpretation of the planning permissions. It's a question of law. I'll come to the principles governing the interpretation of planning permissions shortly, but it's a question of law applying the principles in question. And see also at the bottom of page 264, 15G to H, and just for your notes, really, the point was emphasised in relation to further variations at various parts of 265 and 266. There was in the judge's finding a lengthy established practice of applying for and obtaining variations to specified aspects of the overall development. I draw attention in particular at page 265 at the very top, that A to B, the judge found that the council knew exactly what they were doing. There was some question that before him as whether this was whether the council were fully aware of the wider development when they were granting those variations. He found that was the case for various reasons, including it was a very large development, as I foreshadowed a moment ago by reference to the master plan, in the context of a small community at Abu Dhabi. No doubt, he says at E, the authority regarded as a very important development, took a keen interest in how it was implemented. Inconceivable they weren't aware of the progress of the development, and also various of the applications referred to the fact that work was already carried out.
Just taking a little time over this, the houses that were built under those permissions were not in the position shown on the plan approved as part of the original permission.
Correct. Yes, correct.
So really the situation from a very early stage was it was discovered that the development could not be built in its entirety.
Yes, and that was one of the issues before Mr. Justice Drake.
The
yes.
original permission.
Yes, initially because of levels, because one doesn't really get that from the master plan, but it's a very steep, as the name suggests, hillside, the clue's in the name, very steep site, and there were difficulties with levels, particularly because of some former quarrying works, which necessitated those early refinements, which started that established practice. But my lord is absolutely right, and that point was squarely before Mr. Justice Drake and dealt with by him.
What does it mean to vary the planning permission?
Right. Well, my lord, I was going to come with this later, but I'll deal with it now. It doesn't mean to amend the actual planning permission. And my learned friend's submissions, that I'm going to elaborate later, aligns what I'm suggesting with that concept. It doesn't mean that. It means to grant a permission, a separate permission, the objective intention, of course it must be the objective intention, of which is to operate in conjunction with the earlier one. So that it amends the development approved by the earlier permission, but it doesn't amend the actual earlier permission itself. It operates in conjunction with. And that's why it's not an amended planning permission. It's a planning permission for an amended or modified development or variation.
Why isn't it a new planning permission covering the whole?
Because there's no power to amend a planning permission except in relation to what's called a non-material amendment. There is a power to apply for whatever you want to apply for, but you can't actually amend an actual planning permission as such.
But you can give a new planning permission.
You can give a new planning permission.
So
The whole site.
Well, these weren't for the whole site. These were for specified variations.
But doesn't it have to be for the whole site implicitly?
Well, no. Well, that's my case. Is it doesn't, and I'll hope to make that case during the course of my submissions.
But my question, I think, along the same lines is why, since you can't have variation on a planning permission, but you can have a separate planning permission, why isn't the appropriate way of looking at the variations as new planning permissions covering the whole site, incorporating by reference that which is said to be varied?
That's essentially its effect in substance, albeit they're two separate two separate documents. That's my point. One doesn't say there's one document, the 1967 permission as amended. It's the development approved by the 1967 permission, that development as thereafter amended by the later permissions. But I take my Lord's point about incorporation by...
Sorry, how do you amend a development? I can understand you can amend a petition, at least in theory, although there's no code about it.
Well, but for example, can I answer that question by reference to the post-1987 permissions? I'll show you. If I haven't answered it, please do come back to me, my Lord. I think I'll hope to illustrate that point. But by the very process that happened, I should stress that the issues before this court do not include, despite some suggestions by my learned friend, whether or not it is possible in principle to have a permission which varies the development approved by an earlier one. That was the subject of findings by Mr Justice Drake in this case, which weren't appealed, endorsed by His Honour Judge Keyser at first instance and not cross-appealed. So I completely understand why my Lords are wanting to understand how it works, but that's not a point taken by my learned friend. Can I then just finally just take... Sorry.
The development that was carried out on the basis of the pre-1987 permissions, which you describe as variations, in itself, even if it wasn't impossible by virtue of the ground conditions, the development that was carried out also made it impossible for the original scheme to be implemented.
Exactly.
So the problem is there from the time that this was looked at.
And findings in our favour twice at first instance not challenged, that didn't preclude further reliance on the 67 permission. So I say, well, why so in relation to the post-87 permissions? What's so fundamentally different? What principled basis is there in law that the development industry can follow in future cases to distinguish the post-87 permissions from the pre-87 permissions?
But I'm struggling with the idea that somehow we're bound by whatever Mr Justice Drake thought about this. Don't we have to understand how this works?
You certainly have to understand it, my Lord. I'm just making the point that it's not something which... if I show you how His Honour Judge Keyser dealt with it in a moment, because His Honour Judge Keyser looked at it again, so I'm not suggesting that this is the end of this is only the beginning of the legal journey this case has taken to reach your lordships. But it was reconfirmed by His Honour Judge Keyser and not the subject of a cross-appeal and therefore not in issue before the Court of Appeal. Can I come back to that, my Lord, once I've taken you to the Court of Case, if you still have concerns?
Well, I just want to know how you put your case at the moment in relation to each of these successive variation points. Are you going to come back to that?
Yes, I am. I endorse what Mr Justice Drake said, and also His Honour Judge Keyser, who put it in more modern parlance. So can I come back to that after His Honour Judge? If it's still not clear, please do press me.
I also put this in context for people who may not be as familiar as some people here are with how planning works.
Yes.
Before you got your, I don't know how things happened in 1967, but nowadays, or at least I would imagine nowadays, if you were going to apply for planning permission for a housing development on this scale, you would there'd be a great deal of work done by a variety of consultants, and possibly a public inquiry.
Possibly, yes.
Before permission was granted, so that you would incur perhaps seven-figure costs before you got a permission like that.
Yes.
But once you've got it, if it can't be varied in the way that you're suggesting, as and when problems are found on site in developing it in accordance with the permission granted, if the alternative is that you have to apply for a fresh permission for the entire site, what would that mean for the process of obtaining the second permission, or the third, or the fourth, or the fifth permission as you move across the site?
potentially very considerable cost and delay. It depends on the circumstance. There's a section of the printed case that deals, of our case, that deals with it, which is, well, principally paragraph 40. Some of the paragraphs either side, but I deal with that in writing. There may be some instances where the current up-to-date planning regime provides a workaround, but only in some instances. And I've explained why at paragraph 40 of the printed case. I may come back to that later, but I'm conscious I've only got 2 hours, or just over 2 hours to make my case. So, my lords, the last aspect of Mr. Justice Drake I want to draw attention to in particular was paragraph 20, so page 20 internally, page 269 of the bundle, at C. So the finding of Mr. Justice Drake at that time, which led to the declarations he granted, was though development's gone on very slowly and with a number of variations in the sense I've described, and he found the master plan remains in force, and if development is allowed to progress further, it completed substantial in accordance with the master plan, and he granted the declarations accordingly. The pre-87 permissions that were before the courts below, as I said a moment ago, are in the permissions bundle at PB 1 to 6. As it happens, the material before the courts didn't include all the pre-87 permissions. Nothing turns on the ones you don't have. If you want them, we can give them to you, but nothing turns on them. I don't think Mr. Lewis suggested anything turns on those ones. Critically,
agreed that those led to those.
Yes, correct. Yes, we don't agree that version of the plan, but in terms of where in the overall development site, that's right. There was a dispute never resolved, I don't think needs to be resolved before you as to which of the competing plans was more accurate. I'm not sure anything turns on that, but yes, my lady, in terms of which bits, it's that bit at the south.
Just so we understand the realities,
yes,
those early developments were served by the estate road that goes off at what you might call the bottom left-hand corner of the southerly tip.
Yes, I don't have the plan, I think that's right. Yes, but from recollection, and that. I'm going to come on to the implications of the 1980s pre-87 permission shortly, but
I just want to clear up.
Yes,
it didn't require access across building or access across estate roads on the main part of the
it did. There's findings and indeed evidence from the respondent below that those pre-87 permissions themselves necessitated realignment of the internal roads. So, yes, so there's a common feature to both, which is, I apprehend why you asked the question.
Right, well,
it's a common feature.
Helped by being taken.
And I'll show you that in due course. I want to...
It's just that looking at the plan itself, it's
harder to see.
Perfectly good estate road at the bottom.
Yes,
but
I'll show you the evidence and I'll show you the factual findings below. Right. One point I want to draw your attention to in particular is that all but one of the pre-87 permissions did not use the word amendment or variation.
Did or did not?
Did not. So they were construed as such, despite not having that label. I mention that because the absence of that label on some of the later permissions is relied upon by my learned friend. They were construed in substance as variations for the reason the judge gave.
I appreciate you have limited time, but it's important we grasp practicalities.
Absolutely.
As a matter of practice, would it be a more sensible way of approaching a development of this kind to apply for outline planning permission and then with supplementary applications for detailed permission as you move across the site?
Nowadays, there may be all sorts of other reasons why one might apply for outline permission to provide flexibility in all sorts of ways, timing as much as anything else. Or indeed, if it's going to be sold on to another developer, they could then have their own reserve matters suiting their particular type. So, in reality, a lot of developments of this scale would be outlined now. Would it resolve the or avoid the issues in this case? No, it wouldn't. It's easier for me to explain that later rather than now, but no, it wouldn't. So after Mr. Justice Drake's judgment, as the court knows, further refinements to specific parts of the development were identified, and the parties continued the established practice referred to by Mr. Justice Drake of dealing with these by way of specific planning permissions intended to operate in the way I've described in conjunction with the 67 permission, authorising specific refinements whilst working with the remainder of the 67 permission. And I do want to show you those permissions because obviously they're the ones that relate directly to the legal issues before the court. PB7 or MS 410 is the first one. And you only have the permissions, rather than the actual plans are before the court. Again, if anything, I don't think they do, if anything does turn on, then we can provide anything further. But at 410, you see that this first one, continuing that sequence of identified by Mr. Justice Drake, is described in bold text as variation to detailed approval TYW 1115P. That is a reference. The TYW 1015P is a reference to the 1973 permission, which itself altered the layout in the master plan. So the overarching master plan position was modified in 1973, found to be valid by Mr. Justice Drake, and that was then, if you like, remodified by this permission. And it's plain on the face of...
And did the 1973 one cover the whole site?
Yes, that's actually not before the court, unfortunately, in evidence, but Mr. Lewis accepts in his submissions that it altered the whole layout.
And so, just so I'm getting it clear in my mind, page 220 that you showed us, that was the original...
That was the original 1967 master plan. You don't have, unfortunately, the 1973 plan. If you want it, I'm sure it can be dug out and provided to the court, but it wasn't in evidence, which is why I thought it was inappropriate.
I mean, is anybody seriously suggesting the 67 permission is still in existence?
Yes, that's our case.
73...
Well, they operate in conjunction.
And covered the whole site?
Yeah, well, the 73 operates in conjunction with the 67. The two operate. So the 73 effectively amended the 67 with a modified layout. As I say, if you I don't think anything turns on that, because that was, say, the finding of His Honour Judge Mr. Justice Drake in 1987 was, in light of the 73 permission, the 67 remained the governing permission, albeit with later amendments.
I'm so sorry to take up
No,
this, but I thought that there couldn't be amendments.
Well, there were amendments to specific parts of the site, which meant that overall the site changed in the way that it had. So if 2 or 3 dwellings were changed in one part of the site, that obviously meant that the overall master plan changed to take into account that localised variation, if you see what I mean. Can I come back?
As a matter of law, it has to be analysed as a fresh grant of planning permission, doesn't it?
They all are. They're all fresh grants of planning permission.
Previous one,
but the point is,
with an adjustment to the layout.
Not at the expense of the ability to build the overall development. That's the critical point, because that's now what they say. Again, I don't apprehend a point to be taken about the 73 issue, which is why you don't have the plans for that. If the court would like that, I can provide it.
I'm assuming that the 1973 planning permission was a planning permission for the whole site.
That's how it's been characterised. In the sense it would change the layout, is how it's been characterised.
But isn't that right in law? That it's since you can't have variations of planning permissions, as I understand it, in order to take effect for the whole site, doesn't it have to be a new planning permission for the whole site?
That one, yeah. I mean, the difficulty is I'm answering a question about the 73 permission in abstract without the material before.
Well, each of these has to do with your case.
Yes, each of these. I mean, each of the permissions granted, I say, are all valid, and they operate cumulatively in conjunction with each other. That's the critical point. I'm not sure anything, but particularly nice to find to Mr. Justice Drake in His Honour Judge Keyser, as I'll show you. I don't suggest anything turns on 67 versus 73. Can I just highlight those, so the critical point in relation to the post-87 permissions, starting with this one, but it's a practice repeated in the later permissions, is that they are expressly, some of them, and some of them necessarily implicitly, described as variations to the existing framework, if I can call it that, governing the site.
But they all refer to TYW
which correct
stroke 1115
correct
P, which is the 1973 permission.
Which is the 1973, which is updated the 1967. So it's a sort of grandfather, effectively. The 60 zone is the grandfather of this one, essentially. And what I say to the court about this, and indeed the other ones that use this formulation, is expressly they were granted on the understanding that the consent it varied survived so far and would survive following the implementation of this consent. I mean, that's obviously the stated objective intention of this permission.
How does that apply? Suppose that after these green houses were built, suppose that this part, this southern peninsula, as it were, was sold off to somebody else. Do you still say that further planning permissions in relation to that section are to be treated as variations of the original planning permission, even though some of the land is now no longer owned in the same...
Yes, because the planning permission runs with the land, so the ownership doesn't govern the doesn't govern the planning status of the site. It would whatever is the governing planning framework for the site would apply whoever owned which parts of it.
Right, so that by seeking planning permission for this area, which presumably includes a plan which just focuses on this area.
Yes.
So how can you tell from that how much of all this area around is varied by that?
Well, they go and look on the planning register and see what are the planning permissions that have been granted for variations. They look at this, they see the areas that this relates to, and they see, well, that part of the site. This will become clearer if I go through the relevant facts. I'm conscious I'm half an hour into my submissions. I don't want to shut any questions down, but I need to take the court through the rest of the submission. Yes, and this permission starts the sequence of application numbers of the post-87 permissions, the 300A. They all have interlinked application numbers. Then the next permission in the sequence is PB9, and in relation to that I simply say ditto. That's also expressed to be, that's page 291 of the electronic bundle, expressed in essentially, for present purposes, the same terms.
What page?
291 of the electronic.
Oh, okay.
That's also as variation to TYW, etc. The next one after that, in 2000, page 412, is the first of some of the permissions that relate to plot number, comma, the Hillside Park, which was the then name of the development site. And that's a specific identified plot within the wider development site, and the Statement of Facts and Ground records that at paragraph 5b. So again, in cognizance of this being part of a wider development that was ongoing, and remember what Mr. Justice Drake said about this being such a big development, it's inconceivable people wouldn't be aware of it. The next one is at 293 and is of some importance. I just ask you to note this is known as 300E because a later important document refers to permission 300E. So can I just ask the court to bear that in mind? Page 293, it's another as variation to consent. We're now in 2004, so again, as of this date, the understanding on the face of this permission was that the permission being varied was extant as of that moment and was intended to be extant after the implementation of 300E. Then 414 or PB16 is another plot number, Hillside Park, and I've made my submissions about that. 414, that's 2005.
And these plot numbers, they appear on the 1973 mark.
I need to check that, but right. They certainly record in the Statement of Common Ground. They relate to the master plan.
I think so. Since these documents do refer to that,
yeah,
and certainly I would be assisted by
the Hillside Park. They are the identifiers of where within the wider development site a particular plot is. So it's not, in other words, it's looking at the application as part of a wider whole rather than with blinkers on.
I'm on 414.
414 should be a...
Where is the cross-reference to the 1973 permission?
Oh, that's a plot number Hillside Park permission. Remember, there's two formulae used in the post-87 permission so far. There's as variation to or plot number the Hillside Park.
Yes, that's why I asked my question about the master plan.
Yes.
But I think it would be useful if we could see the master plan, at least then we can tie.
Yes,
hopefully,
I'll make sure that's provided to you. I can't say whether it's provided this morning, but I'll make sure it's given to you in good time. Then the last one, before I turn to that, I need to show the court a letter from the respondent that foreshadowed it, which is of some significance, and that's at MS 298. Which hopefully is a letter dated the 10th of October 2008 from the authority to Mr. Maiden Senior. Yeah. And at the time, this refers to what was a proposal not yet sought permission for 2 pairs of dwellings. It became 3 pairs. Nothing turns on that. And I draw the court's attention to the second sentence in particular of the second paragraph. It says, as permission 300E, and if you recall, I showed you which one that was, which was a variation to formula permission. As permission 300E has been commenced on that part of the park, that is now the extant permission, and I highlight these words, on this part of Hillside Park. Because what was intended or proposed prior to this letter was that the permission I'm going to show in a moment was going to be another variation to the 73 permission. And what they were saying is you can't, because the 73 permission has been varied by 300E on this part of the park. And then the next paragraph again, the last sentence, the avoidance of doubt, once a variation to the 67 permission is approved and commenced, then the 1967 permission on that part of the site ceases to be valid. And that is consistent with our case and the way that I've formulated our submissions on the overarching issue. The part of the site doesn't deprive ability to rely upon the original permission in relation to the parts of the site where there have been no variations. And that is fundamentally our case. And so because of that, they said you have to apply for a full standalone permission for where those 2 pairs, which became 3 pairs of dwellings, was to be. And that permission is at MS 296. It's actually 2 pages before. And you'll see that is formulated differently as opposed to being a plot number Hillside Park or a variation to TYW. That's full application of the construction of 3 pairs of dwellings. And that formulation was a consequence of that correspondence I've shown to the court that related to the effect of the Pilkington principle being to affect the part of the site to which the variation is related as opposed to the whole. And I say, though it's formulated differently, this permission for 3 pairs of dwellings was plainly a permission that was to operate in conjunction with the existing framework of permissions for the development. And I just want to make a few points in relation to that before I then move on to the rest of my case. So firstly, as a matter of context, it forms part of a decades-long sequence of established practice that had been confirmed by the High Court of applying for focused changes whilst leaving the rest of the permission intact. Was sequenced, it was a 300 number permission, and standing back at a reasonable reader looking at this permission and being aware of the planning history on the planning record, the other permissions, I'd suggest plainly not read this as intended to be at this permission for 6 dwellings to be intended to be at the expense of a 401 dwelling permission, the development for which was being rolled out. I mean, it would get real, is what I say to my learned friend in relation to that. If I'm wrong about that, and if there's, at the very least, if there's any ambiguity in applying established principles allows the court to look at extraneous material, and then that letter is the answer. Because ordinarily extraneous material isn't relevant, but if there's ambiguity in a permission, it is. and that's set out in the case law cited by His Honour Judge Keyser at paragraph 49, and it's a fair summary by the judge below. So, putting all of that together, I say that, like the pre-87 Commission, each of the post-87 Commissions was applied for and granted in full cognizance of the 67 Commission, and were intended objectively to operate as amendments to what had previously been granted. They were characterised by the Court of Appeal as authorising departures from the master plan. That's Lord Justice Singh at paragraph 16, and indeed my learned friend's opinion, which started this whole process, characterises that too. So they were, on any view, bore the wider development in mind. Then, my Lord, can I briefly show you, just to complete the picture, the plan of 299, which is simply to illustrate, and don't make a legal submission out of this, but to give the court the picture of where things now stand on the ground. It is the plan at 299.
Is plot 17 that we were talking about the one, could be the one numbered 17 here?
The last one?
Yeah.
I will need to check. Can I confirm that after lunch? I think so, but I don't want to tell you and then get that wrong. But effectively, the northwest is the post-87 and the south is the pre-87. Then what happened is at page 330 of all the references are to the electronic bundle, unless anyone wants otherwise. Page 330, some years later, in this letter dated the 23rd of May, the local authority did an about turn. So having been party, rightly or wrongly, but having party to that decades-long established practice that we've just the court's seen, in 2017 it said it's of the view it won't be possible to implement the original permission further because of the proposition that my learned friend seeks to advance before this court. And they say that on the basis of council's opinion. That is of some significance because, insofar as my learned friend says this is all a matter of planning judgment for local authority, well, no planning judgment was exercised here. The local authority relied on council's advice. That legally, it can't be done. And so planning judgment isn't a fig leaf that the respondent can hide behind in this case. And can I just show you that the council advice itself is a couple of pages later at 334. It begins, and the summary, the penultimate sentence is that the series of additional permissions, no distinction is made between pre and post 87, makes it impossible to complete the 67 permission, and therefore the 67 permission is no longer capable of being relied upon. And the reasons given are MS 338, paragraph 18, and again the proposition is made without distinguishing between the pre or post 87 permissions. And the extremity of the U-turn can be seen from paragraph 38 of the judgment of His Honour Judge Keyser below. That's at page 172. Halfway down paragraph 38, the proposition is from the very moment when the first house was built on site in the spring of 1967, in a position different from that shown in the master plan. It's been impossible to carry out development in full compliance with the 67 permission, and therefore everything from that date was unlawful. So that was the basis, that was the rationale for the authority's change of heart, that for decades everyone's been barking up completely the wrong tree. And note also in this context that the respondent's evidence before the High Court, I don't have time to take you to it, but I'll give you the reference, it's page 399 and following, didn't attempt to draw any material distinctions between the pre-87 and post-87 permissions, other than the latter post-dated Mr Justice Drake. There's no qualitative difference.
Has there been any building actually not covered by an additional permission, i.e. any building actually according to the 19...
No, none of, well, it depends what my lady means by building. No houses have been. I think there's some infrastructure was.
I thought there was a number of houses part built that have been stopped pending the outcome of these proceedings.
I thought I didn't comprehend that was the question. I'm so sorry. I thought the question was have any buildings actually been built in accordance with the 67 permission? And the answer to that is not yet. But that was the position as of Mr. Justice Drake, and Mr. Justice Drake considered that didn't mean that the 1967 permission hadn't been implemented. And again, that's not an issue before this court. It's agreed that the 67 permission has been implemented.
Well, correct me if I'm wrong. I thought that, as we are now, there had been an attempt to start building some buildings in accordance with the original permission rather than separate new ones.
Yes.
But they've been stopped pending the outcome of these proceedings.
Can I confirm what the latest position is after lunch? If I can get back to you on that.
My Lord, if I can sort circuit matters by assisting with that question. The houses under construction are pursuant to the additional permissions also, my Lord, under construction. Right, yes. So the factual position I can record and confirm is that none of the houses approved pursuant to the 1967 master plan are either built or under construction.
That's my understanding, so I'll double check whether anything's materially changed on the ground recently, to which I say, well, so what? Ultimately, see Mr. Justice Drake. Now, the absolutist position was rejected by His Honour Judge Keyser, and can I just again take you to a couple of passages? These really do provide vital context to considering what is before the court. So it's paragraph 48 at MS 177. I'll deal with it briefly because I quoted at length in the SFI and in the cases. But firstly, at 48, halfway down there, the judge says, although it's correct that it's strictly improper to speak of variations of permissions, which is what I don't do, I say variations of the development, I don't find that objection persuasive. I see no reason why a grant of permission might not, on its true construction, authorise development in accordance with an earlier permission, i.e. the master plan, but with a specified modification. That's my answer to my Lord Sales's question. I hope it's an answer anyway, and if it's not, please do press me, that what do I say has happened? I say that. And that finding, as I say, wasn't the subject of any respondent's notice.
So that analytically does seem to be saying you look at the later permission and say it incorporates.
Yes, that is. I think that's.
And that's what you're saying is the true.
Yes, that incorporates. Right. You read them together effectively.
But that only applies to the development authorised by the later permission, doesn't it? I mean, suppose it's for building 5 houses.
Well, it's still, the point is that they're intended to, and the critical point for present purpose, when I get to Pilkington, I will show you how it fits in with the case law, but is that the later permissions on any view, however they're characterised, were not intended to be at the expense of the unaffected parts of the earlier permission. They're intended to work in conjunction. Objectively by the parties. I mean, I'm not saying by one or the other, because that's not.
And you say that would still be objectively the case, even if that area had been sold off to somebody else.
Yes, I will, and I'm going to deal with the kind of planning.
And if there was a planning permission by somebody else for this part, then it would also be intended to be a variation of that, or of only.
Which part, my lady? I'm so sorry.
Well, one of the parts that's not been filled in. So there might be a separate, for all we know, a separate planning thing for that. But how do you link?
Well, that's a matter. That's a question of a planning judgment at the time the variation permission is granted. And I've got a section of my submissions I want to make in relation to that. But the moment for considering how they marry up is not many years after the event, when the authority says, well, actually, we've been leaving up with the tree all along, and actually, you can't build anything now. The moment is when one applies for a permission which is objectively intended and to be objectively interpreted as a paragraph 48, if I can call it that, permission. And when a Keyser paragraph 48 permission is sought, the material considerations for local planning authority include, well, how does it fit together? And that's the moment to consider it. And if they think it doesn't marry up, or they think they haven't got enough information, they can either refuse permission or ask for more information. What they can't do is grant permission, allow that development to be implemented, then later say you've lost your planning permission. Because we didn't consider these issues at the time. Because the public law decision to grant the modification permission, the public law decision to grant the paragraph 48 permission, is something which, once the judicial review time limit has passed, has all the effects in law of of a valid permission, the principle of formal validity and or presumption of regularity. That the things which should have been considered at the time must be taken to have been considered at the time. One doesn't engage in an archaeological investigation as to whether they were or weren't. They're deemed irrefutably by reason of the principle originally set out in O'Reilly and Macman, but reiterated in the Noble case, which I've put before the court. And so one just doesn't go there. I might elaborate that a little bit more, but that's the headline point, and I've made that in my printed case as well. So paragraph 48 is the first, then paragraph 54, looking forward. Paragraph 54, the first part, His Honour Justice Keyser rejects Mr Lewis's suggestion that Mr Justice Drake had adopted the wrong approach. And then the passage beginning a developer, about 7 or so lines down, a developer carrying out single permission must fully comply with the permission. That's the absolutist approach. Otherwise, the entire development will be unlawful. Then he goes this. However, this principle, based as it is on common sense, would be impractical if it was pressed with undue literalism. To the extent of supposing a large complex of development, such as a housing estate, the slightest departure would render the entire development unlawful. He goes on to note that the works done pursuant to the additional permissions would necessarily require some minor adjustments to the state roads around a few points, by Lord Briggs's point. There is some rejigging of the roads around. But no evidence suggests it would necessitate any departure from master plan of the rest of the houses that remain to be built. It did require some rejigging of the houses on the site itself. The adjustment to be minor. Hasn't been established that Mr Justice Drake wasn't entitled to find the adjustment wouldn't prevent sufficient compliance. So a sort of near-miss principle, to use a colloquial expression. So the pre-87 permissions, despite the fact they were treated when the authority decided to change its position as the same as the post-87 permissions, and there was no evidence at all to distinguish them in planning grounds, they were the right side of the line of the test identified below. The post-87 permissions, for the reasons he went on to give, weren't. And can I also, again, I can't...
Sorry, can I just check? Were the minor changes to the roads and so on actually shown in the individual planning applications? So when you apply for the 2 houses or the 3 houses, did that show the roads that would come?
I'll need to check that because the plans aren't before the court.
Right.
But in my submission, it doesn't matter because as they were variations, if the authority wanted to know more, if it didn't have enough information, it could and should have asked for it. One doesn't, again, I suggest, do a very belated exercise in understanding whether the authority looked at all the points it might have done or should have done when granting the modification permissions. They should be taken to have taken into account all relevant considerations about the relationship, and I'm going to come on to that a little bit more.
I mean, the reason for my question was, if they were shown on the individual planning applications, then I'm struggling to understand the point of the observations in 54 if the principle in paragraph 48 is correct. Because if the principle in paragraph 48 is correct, then the whole of the planning permission for the whole site is now as adjusted according to the latest planning permission, with those variations shown in the latest planning permission.
But what I take was that there may be some knock-on effects.
Yes, that's how I call it.
Not expressly spelt out in the planning permission.
That's what I was thinking.
Well, who knows what they, because we don't have in the evidence before the court the officer report for those. Maybe who knows? But I say that's forbidden territory, because those permissions must, as a matter of law, be taken to have had regard to all material considerations, and in the context of a paragraph 48 consent, plainly material considerations would include how the modification fits with the rest of the development. And if they overlook something, that's their problem. It's not our problem to then lose our permission. They can always revoke if they wanted to. They have the power to do that if they think they've overlooked something. What they don't have the power to do is come to this court and collaterally challenge their own decision after the event, which is what, in substance, they seek to do. The witness statement, Mr. Corley, for the authority at paragraph 15, it's page 208. himself notes that the pre-87 permissions, the ones which were found twice by the High Court to be not to have affected the ability to rely upon the 67 consent, mean that the estate roads permitted by the 67 and 73 permission can no longer be built. And again, I foreshadowed that in my earlier answer to my Lord Briggs. So the knock-on consequences, if you like, outside the specific area of the modification, the knock-on consequences were a feature of both pre and post 87.
Which electronic page are we on?
Page 208.
I don't think so.
I don't think so.
Oh, have I got that wrong?
It's the middle of a charges register.
Oh, no, I'm so sorry, 403. Wrong, that was the 403, I do apologise. 403. So I'm probably the last person on the planet who works to hard copy documents.
I'm just thinking aloud. In this case, the problem arose because of unforeseen ground conditions.
Yes.
I suppose in another case, you might get, say, an agreed layout for roads, but the highway authority, perhaps because of passage of time, is unwilling to adopt roads with the sightlines shown on the plan, but wants improved sightlines. Or there may be changes to the sewerage requirements. One can envisage a variety of possibilities where other authorities might insist on changes to matters of relative detail of that kind, but which would nonetheless require something to be done about the existing planning permission.
And this is, I mean, there's a real practical consequence. I mean, we've put in the material some indication of that, and I'm going to try and deal with that if I have time later. But it's a real, of course, the bigger the development, the more valuable, the more important the development, the bigger the problem, because the longer it will take, and also the more time, the more likely is that things like that will change. Absolutely, my lord. And that's why this is a case which the planning sector sees as one of the most important cases for a very long time. It may not be an HS2 or Heathrow, but actually, in terms of real-world impact, this is one of the most important planning cases for a very long time. And I've got an hour and 20 minutes left to make my case on it, so I must continue. So the critical point, therefore, is that these aspects, 48 and 54, which were findings against the authority, were not the subject of Respondent's notice. And that's why when my learned friend says, for example, the Court of Appeal didn't use the term sufficient compliance, well, whether that was the right test or not wasn't a point which he took before the Court of Appeal. What is live, and the critical issue I suggest before the Court, is there a legally principled basis for finding that, in contrast, the position in relation to the pre-87 permissions, in contrast to that, the implementation of the post-87 permissions, which were also intended to operate in the same way, falls foul of the Pilkington principle, means that the 67 permission and or the 73 permission can no longer be relied upon. What's the principled difference? That's really what I suggest the case boils down to. And can I then turn to...
I don't think you can take it, though, because there's no cross-appeal, if you like, that we have to start from the premise that it was correctly decided.
My learned friend certainly does. I appreciate the court will want to understand the rationale.
I appreciate that you can't go behind that.
Yes.
But if the principle would have, if the correct principle would have led to this conclusion, a different conclusion in relation to the earlier development, well, so be it.
And
he's not prevented from arguing that.
Which is why, I'm not sure he does, though, given the way he formulates his case. We will see shortly. But I mean, if I have to, I say, well, paragraph 48 was right. I endorse it. And I hope that's clear from my written arguments. I endorse it for the reasons given by the judge below. And I can develop that shortly, if I may.
Well, I can see what you say about 54 as being a finding.
Yes.
Which, if you like, is another finding about the effect of the pre-1987 permission.
It is, yes.
But the one at 48 is merely him conceiving that in an ideal or hypothetical world, you might find a planning permission that incorporates with amendments an earlier one. I mean, it doesn't seem to go any further. It's not a finding that goes any further.
Well, I mean, even if that's the right way of looking, I agree with it. I endorse it to the court.
Sure.
So in a sense, I don't want to get stuck. I don't want to suggest the court is trapped, if you like, by a failure to technical pleading point. I'm not trying to trap the court. I'm entitled to try and trap Mr. Lewis, but certainly not going to trap the court. But I endorse it. I mean, it's plain because it's very clear from, for example, Pilkington and Pioneer, which of course is a decision of the House of Lords, that a landowner, or indeed anybody, is entitled to apply for planning permission for whatever he wants, whenever he wants, or she, or they. And so the paragraph 48 is a manifestation of that principle. You can't physically, literally amend in the sense of changing the actual document. You can do now for non-material amendments under section 96A of the Town and Country Planning Act. You've got that, but you can't change the actual document. You can create a new document that either incorporates by reference or works with it, as opposed to annuls it, which is effectively what my learned friend says is the
Well, I can understand how it incorporates the old one by reference and variations. I'm in more difficulty in this concept of working with.
Right. I will, by next set of submissions, I hope will seek to achieve that, and if not, please do tell me, and I will come back to the legislative framework. I'm going to deal with my first two numbered submissions together, effectively Pilkington and Pioneer together, because there's a synergy between them. And I'm going to spend a lot more time on this than the other numbered submissions, because it goes to the heart of the legal framework in which the court is looking at this question. And I'll break these first two sections of the printed case, which are paragraph 54 and 56 onwards of the printed case. Break them down into three sections: Pilkington itself, the characterisation of Pilkington in Pioneer, and then where does planning judgment fit into all of this, which I've somewhat foreshadowed already. And Pilkington itself is at MS, well, the relevant part is at MS 724. The statement of facts and issues contains a summary of what we say are the relevant facts. In essence, there were two permissions, each of which was for a single dwelling on different parts of the site, and each of which contemplated that there would be no more than one dwelling on the site. They were therefore irreconcilable. The latter one had a condition, as you will have seen from the way we've described it. The first one, the development, was a house in a small holding. And Mr. Pilkington's attempt to persuade the court he could run them cumulatively to build two dwellings when he had two permissions each saying no more than one. And that's the attempt that failed. The relevant part of the judgment starts at 724. I'm not going to spend time now taking each of the passages that have been quoted below, because that's just going to waste the time that I have. But I want to draw attention to one particular feature, which is at F to G of 1531, Law Report 724 of the MS, where you see, of course, special cases will arise where one application deliberately and expressly refers to incorporates another. We're not concerned with that type of application in the present case. I would add, it doesn't need to be expressed. Necessary implication is good enough. The question is a planning permission one which is intended to modify an already approved development, or is it intended to be something which is to be at the expense of whatever other permissions are, in essence? But on its terms, Pilkington was carving out that category from the principles that it set. And I say that's vital context for reading the statements of principle, which I imagine the court is fairly familiar with now already from the written material about physical impossibility, etc. I think it's also, suggests it's also, my lords, important to appreciate that if Mr. Pilkington had succeeded, there would have been a bypassing of planning regulation. I mean, he would have obtained authority to build two houses, despite each planning permission being on the basis there should be only one dwelling. And in the context of what I'm going to call for shorthand paragraph 48 permissions, there is no bypassing of planning regulation.
But what do you say about the passage at H, which seems to me directly contrary to your previous submission, of there being some kind of duty which one must assume has been complied with by the local authority to marry up, I think the phrase was, one planning permission with another planning permission.
Paragraph H.
So there's no such duty.
There is no such duty in a non-paragraph 48 case. But you have to read, I suggest, the paragraph at H in the context of the carve-out at F to G. That paragraph H, I suggest, is not talking about the kinds of cases of which paragraph 48 permissions fall within, of that he is referring to at F to G. So read that in context. I hope that's an answer to the question.
So you say we are a special case of the kind that which you're calling as a paragraph 48 case.
Yes.
And that rejection of any kind of duty on the part of the local planning authority doesn't apply.
Yes, that's right.
Case.
Yes, subject to the proviso. I'd suggest that the term special case isn't perhaps particularly apt, because that suggests that it's suggests there's some sort of numerical comparison between the two, just other cases, and as I say, it doesn't have to be expressed, but subject to that proviso, the answer to the question is yes. Going back to the planning, there's no bypassing, whereas here...
It's a statement of the obvious, really, isn't it? Yeah. But if most planning applications will relate to independent development, so you treat them as an independent application. But if you have one which is clearly seeking a variation, in inverted commas, of an earlier development, then that's what Lord Widgery was talking about at
exactly
F to G.
Exactly, and then that all ties into my point about relevant planning consideration, because if it's that kind of category, plainly the material considerations include relationship.
In a certain sense, it's not a special case, because on this analysis, there is no inconsistency. It's just that the later one allows you to do something which, if you only relied on the earlier one, you wouldn't have been allowed to do, but you've got permission to.
Yes, that's the way of looking. I mean, the critical point I seek to rely upon by the reference to special, or as I say, I would prefer other cases, is Pilkington was not setting down a hard and fast rule that applied to the situation such as this one, where you have a quote-unquote variation. It was, and so, my lords, can I just go back to the planning regulation point, because that is quite fundamental when we look at Pioneer, because if I'm right so far on the characterisation of the additional permissions, then the appellant isn't seeking to gain more than it bargained for, to coin a phrase. It's seeking to achieve the very outcome that was the intention of the additional permissions, namely development in accordance with the master plan subject to the changes. The Pilkington principle, as the court knows, is not statutory. There's no legislation constraining you. You're the Supreme Court dealing with a common law principle, ultimately. And so why not give effect to the intention? What reason is there, if that is the intention, and you have to obviously be satisfied that it was, why not give effect to it? And I suggest that my learned friend has simply no answer to that fundamental question. And can I also, before I turn to Pioneer, there was, when I was reading through the authorities, there's a pithy summary of ultimately our case on this in the Journal of Planning Laws commentary on the Robert Hitchens case, which I'm going to come to later, which my Lord Sales was in, and that's in MS 797. I deal with Hitchens in the context of Sage, but at 797, you'll see comment. The structure of the Journal of Planning Law ordinarily is there's the case report and then a comment from the editor. And there's description of Pilkington, which was fleetingly dealt with in Hitchens, not in a way that really helps the court one way or the other in this case. And I just he refers to Pilkington and then various cases, and it's in many cases more complex, aren't the outcomes of pragmatic responses to circumstance individual cases, where I say the outcome here wasn't pragmatic. And then this: 2 permissions should be made to fit together if that was envisaged, but unplanned doubling up of development is prohibited. I suggest that's a rather pithy way of, perhaps pithier than I've managed so far, to summarise our case on how the principle should operate. Pilkington itself was a doubling up case. Hillside is not a doubling up case. So I endorse that brief but pithy comment. Can I now turn to Pioneer? And I say, by way of overarching submission, that the analysis I've given so far is consistent with and supported by the consideration of Pilkington in Pioneer. And that begins at 728, but I'd like to take the court to 737 first. I'm going to quickly trot through the context because I can make my submissions on abandonment at the same time rather than to come back to Pioneer twice. So 737, at C to F, there's the passage that has been quoted in the written case about comprehensive code that the court will be familiar with from the written arguments. I highlight in particular section 33(1) of the 1971 Planning Act. This is in materially the same form of section 75 of the current 1990 Town and Country Planning Act in England and Wales. Don't need to go there, it's MS 632. If you want the equivalent position to Scotland and Northern Ireland, we can get those for you. But then, without prejudice, the provision of this part of the Act as to duration, revocation or modification of permission, any grant of planning permission shall, except insofar as the permission otherwise provides, endure for the benefit of the land and of all persons for the times being interested therein. And it was that provision, as then analysed by Lord Scarman at the bottom of page 141 of the law report on the top of the next page, it was that provision that led him, and with him the other members of the House of Lords, to take the approach at 738 G to H that the introduction to planning law of a doctrine of abandonment by electioned landowner cannot be justified because the legislation, comprehensive code, says the permission is yours forever, save where the legislation provides. And then over the page at, I'm using the bundle references rather than law report reference, 739, a passage at A to the beginning of B, where Lord Scarman says there are, however, some cases which at first sight and for analysis might suggest that there's room for a principle of abandonment more widely than those cases, and the three classes of case. Class 1 is abandonment not of a planning permission but existing use. That's dealt with at 143B to F. Then F turns to the second case, the new planning unit. I don't need to dwell on those points, but that's the second category. Excuse me, in the third category at 740, starting just after below B, the third category is Pilkington. And the first part of this thing is describing Pilkington. The real analysis, I suggest, is over the page at 145, or 741, depending which page you're looking at. And just above B, you see the reference, I think foreshadowed in one of the documents I took you to earlier, that Pilkington was certainly a common sense decision, necessary of the courts to formulate a rule which would strengthen and support the planning control imposed by legislation. Well, as to that, I say, yes, it was in a non-special or other case, in a pure Pilkington case. It wasn't the facts of that case, because Mr. Pilkington was trying to get 2 houses when he only got permission for 1. But applying it to situations such as the present case, where later permissions are plainly not intended to annul the earlier, they're not intended to operate at the entire expense of the earlier one, doesn't represent common sense and isn't necessary to support development control systems. No net loss of planning regulation, and in light of what I say is the common intention of the parties, variation, etc., it doesn't make sense to treat the implementation of those permissions as negating the ability to build out the rest of the the areas entirely unaffected.
Well, but if you could only do that subject to some modification of the proposed build for those areas, do you say that that's something that the local planning authority assumes will be the subject of some later application when they're doing this marrying up exercise?
Well, the marrying up exercise can happen in one of 2 ways. I mean, either the application to modify should itself persuade the local authority that the marrying up is at the time of the modification application is adequate, and they could and should have considered that. In any subsequent case of this nature, they could and should. The court, if my submissions are upheld, I'd anticipate the court might want to make that clear, that that's something that the authority has to consider at the time. In this case, if it's said by Mr. Lewis, oh well, that doesn't work, it doesn't stitch together properly, my responses to that are: one, that's not a consideration for this court, because if it doesn't stitch together properly, that's a consequence of them not having done their job as a local authority when considering the applications. It could have been challenged.
They challenged it and said, well, wait a minute, what you're proposing here blocks off the access point that these houses all the way over there were supposed to have to the main road or the lake or whatever. And so you can't do that. And if they say, oh yes, but when we come to build those houses over there, we'll do a separate aspect.
That could be one way of dealing with it. There may be many ways of achieving the marrying up. But the point, my critical point is that it's not in the context of a subsequent argument about whether you've lost the original consent that one looks at the marrying up. You look at the marrying up when the paragraph 48 application is submitted, and either you make sure that the proposed variation marries up appropriately at that time. Potentially you could require a Grampian condition or Section 106 obligation to secure some further development or mechanism. What can't be done is to grant a modification on the assumed basis that the modification fits, and then later seek to call into question whether that assumed judgment was correct. In this case, I don't accept, by the way, that characterisation of the modifications. That's a mischaracterisation, but I appreciate your testing the argument.
I wonder whether putting it in terms of whether the later permissions annul the earlier permission is quite the right way of putting it, because I wonder whether, consistently with your paragraph 48 analysis, it would be more accurate to say the later permissions on true construction endorse.
Yes, so that's a better way. I agree, my lord. I was using annul as a shorthand rather than repeating the Pilkington formulation, but I accept my lordship's characterisation of it.
The important point that perhaps one could take, at least from Lord Ridgely, if not from Lord Scarman, is that he's treating the, well, I think on a very quick reading, it looks as though they're both treating the modification as a possibility, but whether permissions should be regarded as mutually inconsistent, or one is modifying another, seems to depend on construction. Rather than being a legal bar on the possibility of a modification of an earlier permission.
I mean, the way I describe it is in the inconsistency principle set out in Pilkington should not be applied in the rigid way that it would be in a pure Pilkington kind of case, should not be applied in that way to a paragraph 48 consent. Because necessarily, by definition, if you're seeking planning permission for a modification, necessarily what you want to do, you can't do under the original permission. I mean, it's axiomatic. And so, therefore, there's obviously going to be, in any paragraph 48, there's obviously going to be inconsistency.
I mean, I would have thought, if you're applying in those terms, saying, I want to modify what went before, the substance of what you're doing is saying, keep everything in place, but with this change that is a modified bit, because otherwise it's not a variation.
Indeed, I'm struggling to find now the 2019 plan I showed you a moment ago, the one that showed where we got to. But on that plan, there's a huge chunk of the development in the top right, which is totally unaffected.
Well, say it's totally unaffected. I mean, that's the issue, isn't it? Is it really totally unaffected? Because one can see that actually it would be affected by what goes on in the southern section or in the northwestern section by what happens to the roads there. And if those are then in different hands at the time, then you're effectively modifying somebody else's planning permission, or requiring them, when they come to build out their planning permission, to modify it to take into account.
Let me explain what I mean by affected, because perhaps I didn't explain it particularly well. It may be affected in planning merits terms on the ground. That's a matter for the evaluation at the time of the paragraph 48 application being considered. It's not affected in a Pilkington sense because it's physically possible still to build them out. And the objective contemplation of the additional permissions is that they would still be built out.
Well, even if it weren't, I mean, the problem in Pilkington was that each permission was only for the construction of one house on the site, and so you couldn't build out the permissions cumulatively.
It was a no-brainer, that case.
Yes, quite.
I mean, they were just truly alternative.
Yeah, they were true. Yeah. Well, in fact, my lord, I forgot to tell you, the Secretary of State decision, which was the subject of the judicial review in Pilkington, used that very word. The finding of the Secretary of State, which was then challenged, which led to Pilkington, was that the two permissions were alternative. That's exactly the formulation used.
The difference in the present case is that if you have what is on a proper construction a modification, because it says variation of permission, whatever it was, variation of 1973 permission, or it says plot 17, i.e. go and look at the 1973 permission. It may necessitate a future modification when you come to build out another part of the site.
And if I'm right, so what? Because that can be done.
Yeah.
It's a paragraph 40.
But it's a different.
Yes.
It's not the same problem as arose in Pilkington.
Yes. Yes. And again, I ask the court to stand back and say, on this common sense, perhaps stand back and since, for example, when permission is sought for a house on plot 3 of the Hillside Park, is it really common sense to say that the implementation of that permission is to render incapable of further implementation the wider 401 dwelling permission, which has been found by the High Court section? It doesn't make sense.
What is the boundary then for what makes sense and what doesn't make sense?
A paragraph 48 permission. A permission of the nature I've described and of the nature framed in paragraph 48.
But it can be a paragraph 48 permission even if it means that when you come to build out something else on the site, you have to modify that from what's the plan.
Yes, for the reasons my Lord Reid just elaborated. Yes. Yes. Because if a paragraph 48 permission is...
What's the benefit of to you of
that?
48, yes, operating or not, if you're going to have to apply for planning permission anyway.
Well, because you don't have to apply, the benefit is set out in paragraph, summarised at least, paragraph 40 of our printed case. And the point is that if that isn't a tool at the disposal of people who apply for permission, then in a situation like this, you would in many cases have to apply for planning permission for the whole new permission, for the whole new red line, which is A, extremely expensive. I mean, talking hundreds of thousands of pounds for a large development, if not more. B, can be very cumbersome because then it requires reconsideration of matters which have already been decided, may require development this side, environmental impact assessment, etc. Or dealing with matters again which have already been looked at. So it's not, there's no gap in assessment or anything like that, and it takes time. In the context of a development, say, I mean, this case has, perhaps rather unfortunately, as a test case, risen in the context of National Park, but in reality, as we've sought to demonstrate, and as the thing, there are developments round the corner that are affected by this. Housing developments, wind farms, film studios, a huge range of developments which are in reality affected by this. And it's not, if it was simple to go back and apply for planning permission for the whole thing, frankly, there wouldn't have been the public importance in this case for permission to appeal to have been granted.
So you're saying that the considerations that have to be taken into account when applying for planning permission, what you've described as the whole thing,
yes,
are much wider than would be considerations for planning permission for bits of the whole thing, even if those bits of necessity had to be changed because of what's happened elsewhere.
Yes, they are. I'm tempted to jump ahead to my 6th point, but can I complete Pioneer and come back to that? Because there's some practical points I'm going to draw your attention to in the material you've got.
Absolutely. But there is one thing that I did want to ask.
Sure.
Because on my understanding of your characterisation of the paragraph 48 form of consent, that is a new consent for the whole development. So what is it that spares you in that sort of case where you're just asking for a modification of all the costs and inviting the planning authority to look at it again in the light of whatever the current
it's
situation?
Not a planning, it's a permission which has the effect of endorsing or incorporating by reference. It's not of itself a planning permission of the whole, because plainly not, and they're expressed to be 3 for Hillside Park as opposed to the whole Hillside Park. So plainly its effect, paragraph 48, is to endorse, or whatever the formulation you use, work with, endorse, incorporate. I think they all reach the same destination. Have the effect of granting permission of the scheme as a whole subject to their modification. As a matter of form, not all of them had red lines, but if they were to, the red line would be for a specific area. Indeed, that is the practice as described of the drop-in permission, is you don't have the whole site red line, because that, again, has often complications.
And you say, I take it, that if the local authority are concerned about the knock-on effects of this particular application, they can say, well, we're not going to grant it unless you show us how it will fit in later on.
They could say in any one case, do you know what, we're not going to grant this unless you do apply for full planning permission. This is just too complex to work out. They could say that.
But if they give you permission, you say they're implicitly authorising future development that will be made to accommodate to the original plan.
Yes, my lord. They can't repudiate after the event, which is what Mr. Lewis seeks to do on behalf of the authority. So, my lords, I must press on because I am conscious of the limited time. Can I then just go? So, going back to Pioneer, I've made the points about common sense and strength and support. At F to G of this is back to page 741 of the authorities. Lord Scarman said the Pilkington situation resembles the new planning unit class of case. So the third category of exceptions to abandonment resembles the second one. And he says it's because it's as if the permitted development has been carried out has so altered the character of land that its planning history now begins with the new development. And I say again, that's a characterisation that fits the facts of Pilkington, but is not apt to fit the present case or situations like it. It's plainly the planning history of this appeal sign is particularly complicated. It's plainly, but it's not a planning history where the reset button has been pressed. All the permissions have to be looked at in conjunction with each other. So, again, as a litmus test, a sense check, I say that's helpful. As I do, as well, the characterisation of Pilkington as an exception to the principle that planning permission can't be abandoned. And I'll make the following points in this respect. Firstly, the statutory context and the comprehensive code, particularly what is now section 75, what was then section 33, supports the view that the exception set out by Lord Scarman should be construed narrowly, because they're exceptions from the statutory provision, effectively. Secondly, for abandonment of existing use rights, which is the first of the 3 what Lord Scarman thought were analogous exceptions, the test has been described, and I put this in the printed case, paragraph 6, MS 48. The test has been described as involving consideration of whether the facts will lead a reasonable person making an assumption that the use had been abandoned. I say involving because this isn't a case about precisely where the boundaries of abandonment are, and don't want to set your hairs running. But using that as a sense check, I say it is a useful sort of sense check to Pilkington. My own friend doesn't contend otherwise. He says the answer to the reasonable person question is different to what I say, and doesn't disavow the utility of it as a sense check, at least. Whether it's an analogy, whether it's a part of it, doesn't matter, but as a tool for the court to understand where the parameters of Pilkington lie. And I say, as I do in the printed case, that the reasonable person armed with relevant facts would conclude, which would include the planning history, plainly include the permissions on the record, would conclude in Pilkington that Mr. Pilkington had, by implementing Permission 756, had abandoned Permission 601. But would the reasonable person conclude that by implementing the post-87 permissions, my client had abandoned the right to build out the rest? I'd say obviously not.
Well, but you say build out the rest subject to whatever modifications are necessary to take account of what's already been built.
Yeah, should they be necessary, but subject to the answers I've given already, that A, the marrying up, if it was relevant, I won't repeat my earlier submissions, but subject to the provisos I've given already in terms of what should have been considered at the time and must be taken to have been considered, and subject to, if I'm right, the legal possibility for further modifications. Then role of planning judgment. I've largely, for sure, I'm not going to deal with any other cases other than Pilkington Pioneer in the Pilkington succession, because none of them are variation cases, and most of them are first in, they don't bind you, so I don't think it would help you for you to take time on that. In role of planning judgment, just to kind of package up my submissions on that, I've said a little earlier. In any case, I say, where planning authority is required to determine a paragraph 48 application, they will have to be satisfied that the proposed modification or variation is acceptable. And in planning law, acceptable means in accordance with the development plan, unless material considerations indicate otherwise. In England and Wales, that's section 38, subsection 6 of the Planning and Compulsory Purchase Act. The adequacy, therefore, in planning terms, the relationship with the remainder of development will be central to that judgment. And I've already made clear they can refuse or ask more information or potentially ask for a different kind of application to be made. What they can't do is to grant the variation, many years later say the effect has been to lose the ability to rely on the earlier permission. And can I then take you to what my learned friend says about it? Well, let's start with the witness statement. So it's page 404 of the bundle. This is Mr. Corley's witness statement before the High Court on behalf of the authority. And I'm going to take you to this, then what my learned friend says. Paragraph 19 of his witness statement, he says, from a planning perspective, looking at the site as a whole, the interrelationships between dwellings and state roads permitted by the 67 permission and those permitted by later permissions are important. Now, note what he doesn't say, in fact, he came to the scene after the last of the sequence, he doesn't say they weren't looked at. There's no evidential case by the authority. They say we haven't shown they were, but I say in the context of unchallenged decisions, it's not for us to prove that they were regular. So he says they're important. I say, well, they were material considerations at the time of the relevant decision. That's the critical point. They're not...
But do they ever do that? Do they ever say, or did any of these later permissions say, this is a variation, or impliedly, and that means that you cannot now build those bits of your original plan?
The court doesn't have, well, the court doesn't have the reasoning behind those decisions. It wasn't before the High Court. I think probably because they've...
No, but in the actual permission itself.
You wouldn't find the reasoning in the permission itself, my lady. So the permission...
But does any of them say, as a condition of granting this, you cannot now build what's on that area in the original plan?
None of them say that. They wouldn't need to have that, because if implemented, then obviously they would become the governing permission for that part. Remember the letter, for that part of the site. That is their effect. So they become the framework for that part of the site, leaving unaltered the relevant instrument that authorises development on the other parts. As to whether or not there was an officer report, because normally we're planning case officer.
No, I'm not talking about that.
As to whether there was an officer report, reasoning, was that relationship adequate or not? Who knows?
The point is you wouldn't need a condition prohibiting
Yes.
Something being built which was inconsistent with the building of the permitted development.
Yes, you wouldn't, because it would...
Ipso facto,
Yes.
it
would be yeah, exactly.
You can't build something different on the same...
Exactly, my lord. Exactly. So then can I take you to court also to what my learned friend says in his case? It's at paragraph 12, which by my bad handwriting is 86. I hope that's not another stray reference. And... it's internal page 5, paragraph, actually 13, I do apologise, it's 13. And what my learned friend does is say there's certain things that the authority needs to consider, and the only way they can consider them is by a new application now, which in brackets they wouldn't be inclined to grant anymore. Otherwise we wouldn't be here. but a new application dealing with the things he sets out in Roman numerals, the questions it has not had to consider before this point. Well, I say these were plainly material considerations at the time that any of the additional permissions which bore upon these issues were granted, which could and should have been taken into account at the time they're granted. If they weren't, that would have been judicially reviewable. It would have been a failure to take into account material, fewing 3 material considerations, I suggest.
Yeah, I mean, in a sense, they've been judicially reviewable by an opponent. Yes. Of the grant of planning permission.
Sometimes, very rarely, I don't know whether many of the court has had experienced this, perhaps sitting as first instance sometimes, but very rarely a local authority actually has very quick buyer's remorse over having granted permission, and there's a customary where the leader of the, somewhat bizarrely, a leader of the council, the leader of council planning committee will bring a judicial review in her or his own name. Often there's a consent to judgment, or the developer will, and that has happened. I've got unfortunate experience of one of those a long time ago. So there are mechanisms for an immediate safety check if something's gone wrong.
But also, if a neighbour was saying, yes, this is going to impact on me, they would be entitled
absolutely
to seek judicial review.
Yes, indeed.
But do you say that the council's obligation, the authority's obligation, is to consider not only the effect on the planning permission which has been granted incorporating that part, but planning permissions granted for neighbouring parts and how it's going to affect the
overall of the development site?
No.
Of Abu Dhabi generally.
Well, if you build up, just looking at 438.
Yes.
If you build up that whole area in a different way, it may well affect whether somebody beyond the red line, I don't know whether those little buildings beyond the red line are actually built or whether they're part of somebody else's planning permission, but what's done in there may well affect their ability to build what they've got planning permission to do, but how do they get notified of this?
If that was, well, there's publicity requirements, standard publicity requirements for all planning applications, and this would be subject to those same. The publicity requirements would be the same, whether it was for this first, whatever.
So the local authorities,
they would have to
notify. The assumption is that they look not only on how it affects this development, but how it might affect the ability of somebody with a neighbouring planning permission to develop their...
Anything that flows from what's being proposed would be a material consideration. The publicity requirements in England would be what's called the Development Management Procedure Order. It used to be Article 15, I'm not sure that it still is, but if anything turns on that, we can provide it, or, but it would be notified and consulted in the usual way.
But neighbours haven't been notified or entitled to participate in the process.
Absolutely.
And make objections.
Absolutely. There's no deficit, no democratic deficit in this process, no consultation deficit at all. It's not an attempt to cheat or game the system. Pilkington was gaming the system. This isn't at all. And yet, if anything on this, which we just say we don't accept this plan, but if anything on this plan had, even if, let's say, for example, it might affect traffic movements throughout the site in some way, that would be more bin lorries or whatever going through the route, then that would be a consideration to take into account. But to say, there's no evidence we did take into account, but actually now we think that because we would have to take into account, you've lost the ability to implement the original permission, and you have to apply for a whole new one. That is a collateral challenge. I don't really want to go through the case on collateral... Oh, sorry,
but what's changed between the two stages you're contemplating is the actual carrying out of development pursuant to the later permission. Are you reading back... I mean, plainly, if a development has been carried out, then, if nothing else, you have to ask the question Lord Scarman asked, well, Lord Justice Scarman asked, has that so changed the character of the site that the planning history has to start from that development? But if all you're looking at is two competing planning permission or planning applications, or one permission and one application, quite possibly by different people, are you saying that the planning authority has to consider the implications of an existing but not implemented planning permission when granting a new one?
That's standard. Planning is usually, not always, usually prospective. In a sense, that's inherent in the name. One is making an assessment, an informed assessment with benefit of any expert evidence required of what is likely to be the future consequences, as opposed to relying on hindsight of what's actually happened. So there's nothing unorthodox about it.
No, and you're not saying, as I understand it, that if there is a planning permission like the 1973 permission, and along comes a planning application which overlaps, covers part of that site, that any such comparison has to be made. It's only if, as I understand it, the application for the second permission says we want this to be by way of modification of the previous plan.
Says or otherwise should be taken as say. So I'm not saying expressly,
okay, I don't mean
implicit. So
says either expressly or by
like
necessary
the plot
implication.
3 Hillside Park, I say, is such a one, even though it doesn't say it's a variation, but that's plainly in my submission to be taken as that for the reasons I've given.
Yeah.
And indeed, the pre-87 permissions, as I said, only one of them actually said it expressly, but they were
Whereas
taken.
most of the post-87 permissions do say it.
I'm so sorry, Mark.
Most of the post-87 permissions.
Most of them do. Yes, certainly a lot more of them do, absolutely. So again, it's not a distinguishing feature between the two.
But in a sense, it's not so much what's in the permission as what we have to assume was in the application that triggers that requirement.
Yes, yeah. But I mean, for example, my lord, I mean, whereas if, like, with hindsight, when developments have been put out, Mrs. Jones, who might now live in a house, might herself complain, oh well, now the additional bin lorries from this change affect me. Before she moved to the site, it would still be possible and would be required for the authority to think, well, would the future occupant of that dwelling that's being permitted but not yet being built have an impact on their amenity? And that's commonplace. I mean, it's commonplace for impacts on future occupiers of permitted development, but that hasn't yet been built, to be taken into account. That's vanilla planning in practice. Can I? I say just Noble and Thanet. I ought to dwell on it. It's the best articulation of the principle of formal validity, i.e., unchallenged public law decisions must be given all the effects in law of valid decisions and cannot be collaterally questioned. It's the best articulation of that in the planning context. Obviously, O'Reilly and Macman and Hoffman-LaRoche are the two original authorities, both House of Lords. You don't have those in the bundle, but the relevant parts are cited in Lord Justice Old's judgment in Noble. So.
I think it's there, though, my lord is reminding me, is
It's a planning case.
Is it? Oh, yes, of course it was, actually. Yes, well, modern planning case, I should say, perhaps. Early Mac was under the pre-1990. You're absolutely right, albeit perhaps a conventional planning case. But anyway, when you see Noble and Thanet, I suggest it's the best and most user-friendly articulation of the principle that deals with those. You're absolutely right.
You're saying, just going back to what Mr. Corley says, paragraphs 11 and 12,
yes.
86, you say that if that's what the local planning authority's been doing all those years, they've been under a complete misapprehension as to what their duty is.
Yes, if it was so important, why didn't they consider it at the time? Before we know, we did. They did. But they can't later say this is so important that it means that the whole established practice, so decades long, that I've described, was legally misconceived.
I take it that we don't have any of the application documents which led to any of the individual permissions which say they are by way of variation.
You have the supplementary bundle was prepared with that in mind, but Mr. Lewis has made the point. He's promised he's not going to say anything that's plainly contrary to that, but there weren't any evidence before the courts below, so my hands are somewhat tied unless the court feels it ought to see them. They ben essay, but I'm not going to start trying to get through difficult principles in relation to evidence on appeal, let alone second appeal.
But they do seem to be, I mean, in principle, they seem to be rather important. Because what you're asking us to do, I think, is to say that where we can see an individual permission that's expressed to be a variation of 1973 or 1967, then what the planning authority is doing is responding to a request that it should be Because if there was no request that it should be, there'd be no requirement to carry out that process of comparison.
Let me answer this way. I don't accept they are sort of necessary for me to make my case, because the starting point is planning permissions should be construed on their face, and it's only in the event of ambiguity that one looks at extraneous material.
Yeah.
And I say none of these consents, apart from possibly, which I don't accept, the last one, to which you do have that letter, none of these consents are ambiguous, just as the pre-87 consents weren't ambiguous. So I don't need to rely upon them. Mercifully for me, the last one, which is the one that is not in the formula of one of the two formulas I've described, mercifully for me, there is a letter in relation to that one. So I can rely upon that should I need to, although I say I don't need to. As to the second, if you like, batch of missing information, which is the rationale, if the reasoning, as I say, that's forbidden territory, I say.
Sure.
Right, so,
I'm so sorry to take up time on this, but I just want to get it clear in my mind. Does it work in this way, do you say, that when someone comes along with a variation planning permission application, which cross-refers to the previous permission, which is already in place, and the master plan, that from the point of view of the local planning authority, it's a matter of planning judgment whether they say they're prepared to proceed on the footing that everything else remains in place and that they don't need to review that, or as a matter of planning judgment they might say, well, this changes things so much that we think
you need to change. You need to change.
Have to make a more general application.
They've got a range of tools at their disposal, and so there's no problem with this for that reason. Yes.
But it's within the permissible scope of their planning judgment.
Yes,
I understand you to be saying that they could say we've sufficiently looked at the master plan, that there's a permission there anyway, so that's part of the background of an extant possibility it'll be built anyway, even if we don't grant permission, and then to proceed on the basis that we think we don't need to look more at that.
That's one of the. There's obviously, in any case, there's going to be a range of rational responses. In any case, they might include refusal, obviously, if it's demonstrably unacceptable, requiring more information, but within the parameters of paragraph 48 application, saying actually this has knock-on consequences that are so profound you can't deal with it by a paragraph 48 application. There are probably other responses too, but those are amongst them.
Well, is there a response in between them just granting approval and saying, no, you've got to apply for the whole development?
I wouldn't like to rule that out. I can't think of.
Rather important.
Can I come back to you after lunch? I'll think about that over lunch. One thing that plainly would be possible to do in principle would be a sort of what we call a granting condition in planning. So you grant the paragraph 48 permission and say no development shall commence until for example, a suitable scheme for the alteration of the road in Lord Reed Lane or whatever it might be. So there's ways of dealing with it that way too. There's quite a wide range of mechanisms. All of which support my basic contention that upholding the effective planning regime and a common sense regime doesn't necessitate the outcome that my clients have had so far, and in fact necessitates the opposite. Can I move on to the next? I'm conscious of time. I think unless anything the court feels it would like to hear, I think I've probably dealt with the comprehensive code points fairly exhaustively in my printed case. So shall I move on to go to the practical? I'll come back to SAGE after lunch if I need to. The practical implications, I think that probably flows most from the discussion that's been had. So this is the 5th and 6th submissions in the printed case, which are really policy considerations, which of course, in the concept of a non-statutory principle at this level are relevant. And the 5th submission, which starts at MS 72, paragraph 59 in my case, relates to certainty and predictability. And I say that those considerations are particularly important in the field of planning for the reasons we give at paragraph 61. I do accept, if you want to say, it's probably crying for the moon to expect absolute certainty, not least because many of us in this room would be out of a job if there were absolute certainty. But our formulation of the Pilkington principle provides very considerably more of it than the approach the courts below. Of particular concern, not the only one, and I've set out the range of concerns in the printed case, but a particular concern on the law as it stood before today and stands until the Lords give judgment is, how is a developer, investor, funder, landowner, member of the public, local authority, to ascertain with any confidence which side of the line an additional permission, paragraph 48 permission is, prior to implementing it, and potentially losing the ability to run the main permission for wider development, maybe worth hundreds of millions? And as I said, by definition, this issue applies to the bigger developments, the more valuable ones. How do they tell if their case is one of sufficient compliance, like the pre-87 permissions, or the contrary, like the post-87 permissions as found below? My learned friend says it's all just a matter of fact and degree. There's no need for guiding principles or considerations, and indeed none were offered by the courts below. But I suggest that without any sort of principle, it's an entirely unpredictable, and I venture to say arbitrary, process. Principles tell us what we should be paying attention to in the fact and degree test. And I would venture to suggest that, if not the reason why, one can deduce from the lack of any principles given that the calibration of the test is unprincipled. That's what, if one could formulate workable principles, it's clearly not knock-on consequences, because the pre-87 permissions had those. It's clearly not physical impossibility to achieve the whole of the original consent, because the pre-87 permission stopped that. So what is it? How is a developer or a funder of a £2 billion development in London going to achieve? My learned friend says they can apply for a certificate of lawfulness. But of course, you can only do that after you've implemented additional permission. Then you want to find out what the consequence of having done that. By that stage, the horse has bolted. It's too late. How do you know how to proceed in advance? And in planning in particular, for the reasons I've given, these are really quite important considerations. Remember that
Just on that, could you not apply for a declaratory form of relief from the court against the local planning authority?
If in the event that we were to do X, would that have the effect of depriving us? I mean, in principle, that might be one way of doing it, but in practice, that's, again, a considerable additional burden. And as my learned friend made the point when she tried to strike this case out originally, applications for declaration are the exception rather than norm in planning, because they are another departure from what is meant to be a prescriptive process. Yeah. And I mean, they take time to come on. I mean, this case has taken obviously a very considerable time to come on. This is an application for declaration, and in the meantime, you've got a development that can't proceed.
Yes, what occurs to me is that although this particular case concerns a permission that's taken a very long time to be built out, in practice, large developments will depend on the availability and the terms on which finance is available. And if, for example, interest rates were to rise, yes, that might render a development unbuildable.
Yeah, unviable, or might have effect on affordable housing, or market conditions might change again. The whole point of a drop-in is that circumstances have changed. If you don't have to wait 3 years to fit the remedy, things might have changed on again. It may no longer be an apt remedy and so forth. So I suggest a powerful policy consideration. And again, on this unpredictability, do note that Mr. Justice Drake described the pre-87 permissions as substantial variations too, and that was referred to without criticism by that finding by the courts below. See paragraph 54 of His Honour Judge Keyser and Mr. Corley's witness statement, and I've made my points about the council not distinguishing between the two. So our formulation of the test removes at least the bulk of the uncertainty. There may still be questions of construction in any case about whether an additional permission is or isn't intended to operate as a variation, should it be construed as a paragraph 48 permission. But that would be subject to the well-established principles on interpretation planning permissions. And those principles, well, firstly, their application is reasonably predictable, and secondly, the planning system is very used to working with them. So I'm not saying I get rid of all the uncertainty, but I reduce it if I'm right. That comes under the sixth submission, which is the practical implications. And can I take the court back to my printed case at paragraph 62, which is the entry point for this. So here, really building from the fifth proposition, we make the point that the grant of, say, what is colloquially, is not a term of art, it's not a defined term, drop-in or slot-in permissions to a wider development is common practice in the planning industry. We'll come to the examples, but can I take you to the most useful, I suggest, of the court passages of the exhibit DH1? And the first one is an article at 546 of the bundle, 546. And I did do a check on Westlaw over the weekend just to see if there's anything in any of the for peer-reviewed journals or anything like that on the Court of Appeal's judgment. I couldn't find any yet. But this is an article by CMS Cameron McKenna and Nabaro Olswang LP, and I endorse the analysis here. But you'll see there's the last two sentences of the first paragraph. The court's moving simpler but less flexible system, in contrast to the emphasis on elsewhere on flexibility in planning. There's reference to the practice of drop-in until Hillside, frequently used, provide flexibility. On the face of it now, third, no longer lawful to drop in, and so on and so forth. And over the page, really building on what my Lord Reid said a moment ago about the financial investment side of planning, the last paragraph on page 457, the risk that the Court of Appeal's approach has introduced for developers could have significant programme and cost implications, cause problems at refinancing and disposal of the property. There's then at 544 Herbert Smith Freehill's article, where there's reference in the 4 lines down. The situation as it stands now at the Court of Appeal and the High Court makes life very difficult for developers building out complex multi-phase developments over many years who understandably wish to amend their developments to reflect a changing market or specific tenant requirements. And then because of the combination of the Finney case, which says you can't use the Section 73 process to change the description of development, and Hillside, many developers face the only option of reapplying for planning permission at the time. But given the scale of modern planning applications, this would clearly be disproportionate in a majority of cases. I mean, think, for example, of permission, some of the large permissions for new settlements are 5, 6, 10,000 homes. Think about the consequences of that if this was an option. So that's, and then lastly, the levelling up bill, the explanatory notes. If they could be, you could hand those. Just provide these. You've got, my learned friend refers to the levelling up bill, and these are the explanatory notes that accompany the bill.
You'll send us electronic copies in due course.
We will, absolutely, yes. Yes, absolutely, PDF form. Thank you. So I feel increasingly anomalous with a big stack of papers here, but old habits die hard. So the levelling up bill...
New habits need to be fostered and preserved.
Yes, indeed, absolutely, indeed. Bottom of page 92 of the notes describe clause, and you've got clause 98 in the authorities. I'll give you reference in a moment. But there's reference here, paragraph 570 of the note, and this is currently before Parliament, that section 73 and 96A, which we describe in our printed case under this section, the sixth omission, provide powers to vary or remove planning conditions. That's section 73, and 96A, non-material amendment permission. And then it said the existing framework for varying planning permissions is often seen as confusing, burdensome and overly restrictive by applicants and local authorities. Recent case law has compounded these issues. Now, it's not footnoted, but I asked the court to infer that that's likely to be a reference to the combined effect of Finney, which means that Section 73 can only be used to change conditions. It can't be used to change the description of development, the operative part, and Hillside. Confusing, burdensome and overly restrictive. Contrary to what Mr Lewis has suggested in his printed case, at footnote 12 on MS 112, the bill isn't an endorsement of the correctness of the Court of Appeal's judgment, I suggest. Firstly, the draft of the bill would have been well aware that the final chapter in this litigation is still to be told, but given there's a planning-related bill before Parliament anyway, it's a pragmatic response to the Court of Appeal's judgment to try and dispel some of the confusing, burdensome and overly restrictive, in the event that, I'm sure it won't be, in the event that it's not dispelled when the court gives judgment. And also, of course, it has identified this litigation a lacuna in the statutory regime, which is meant to be a comprehensive code, and there's an opportunity to plug that gap and put it on a statutory footing. For what it's worth, I suggest that if Clause 98, which is the relevant clause, were enacted in its current form, it wouldn't render your lordship's and your ladyship's judgment academic for two main reasons. Firstly, it won't address Pilkington-related issues where additional permissions have already been granted and implemented, and because it relates to varying future applications to vary an actual permission. So existing situations like the present will not be affected. And secondly, the new power to amend would only apply where the effect wouldn't be substantially different. There's a fast-track consideration process where there's a sort of a constrained approach to what are the material considerations set out in Clause 98. Do
we have the text of it somewhere?
You do, yes. It's at MS 908 and following. So the fast-track constrained material considerations approach only applies if the effect wouldn't be substantially different. So
would or wouldn't be?
Wouldn't be. So if there would be a more substantially different approach, then that wouldn't apply. I'm conscious of the time. That's probably I can carry on for 1 minute more, but that may be a convenient moment.
Well, if this is a convenient moment for you, Mr. Banner, then we can adjourn and resume at 2 o'clock.
Thank you.